Somewhere in Washington, D.C., there is a court that most Americans have never heard of. It meets in secret, its decisions are classified. Its proceedings are one-sided, meaning only the government gets to argue its case. And it has the power to authorize surveillance on any American citizen, without that citizen ever knowing, without that citizen ever being charged, and without that citizen ever having the opportunity to defend themselves. It is not a conspiracy theory, it is not fiction, it is a real functioning court, operating inside the United States government right now. And it has approved over 99% of every surveillance request ever brought before it. This is the story of the Foreign Intelligence Surveillance Court, and why every American should know it exists. To understand why this court exists, you have to go back to the 1970s. The United States was rocked by a series of revelations about government abuse of power that shocked the nation. The Church Committee, a Senate investigation led by Senator Frank Church, uncovered decades of illegal surveillance by the FBI, CIA, and NSA, targeting civil rights leaders, politicians, and ordinary American citizens. With absolutely no legal oversight, Martin Luther King Jr. was surveilled. Anti-war protesters were surveilled. Members of Congress were surveilled. The scale of the abuse was staggering, and the public demanded accountability. Congress responded in 1978 by passing the Foreign Intelligence Surveillance Act, known as FISA. The idea was simple: if the government wanted to conduct intelligence surveillance inside the United States, it would need to get approval from a special court, a court with judges, with legal standards, with oversight. It sounded like a reasonable safeguard. What it became is something very different. The Foreign Intelligence Surveillance Court, known as the FISA Court, is unlike any other court in American history. Here is how it actually operates. It meets in secret. FISA Court proceedings are classified. The public cannot attend. The press cannot attend. There is no public record of what is argued or decided. Only one side argues. In virtually every FISA proceeding, only the government presents its case. There is no opposing counsel, no defense attorney arguing the other side, no representative for the American whose privacy is at stake. The judge hears one side and makes a decision. The target never knows. The person being surveilled has no idea. Court just authorized the government to monitor their communications, no notification. No opportunity to challenge the order, no due process in any traditional sense of the term. The approval rate is staggering. Between 1979 and 2012, the FISA Court received 33,942 requests from the government. It approved 33,900 of them. It rejected 11. That is an approval rate of over 99%. Legal scholars have described the FISA Court as a rubber stamp for government surveillance requests. A court that exists on paper to provide oversight, but in practice approves almost everything put before it. The judges are appointed in secret. FISA Court judges are not confirmed by the Senate like other federal judges. They are appointed by the Chief Justice of the Supreme Court, alone, without congressional input, without public transparency, for 7-year terms. For decades most Americans had never heard of the FISA Court. That changed in 2013. Edward Snowden, a former NSA contractor, released a massive trove of classified documents revealing the true scope of American government surveillance. What those documents showed shocked the world. The NSA was collecting phone records of virtually every American, not just suspected terrorists, every American, under a FISA court order that had been secretly renewed for years. The NSA was collecting internet data from major technology companies, including Google, Facebook, Microsoft and Apple, under a program called PureSIM. Authorized by the FISA Court, in secret. The scale was unprecedented. Billions of phone calls, billions of internet searches. All collected. All stored, all potentially searchable by government analysts, and all authorized by a court that almost nobody knew existed. Approving requests that almost nobody was allowed to see, in proceedings that almost nobody was allowed to attend. The government argued all of this was legal. The FISA Court had approved it. Critics argued that a court that approves 99% of government requests, in secret, with no opposing counsel, is not meaningful oversight. It is the appearance of oversight. and there is a significant difference between the two. After the Snowden revelations, public outrage was enormous. Congress promised reform. In 2015, President Obama signed the USA FOTM Act, which ended the bulk collection of American phone records under Section 215 of the Patriot Act. That was a genuine change. But here is what did not change. The FISA Court still meets in secret. The FISA Court still hears only the government's side in most proceedings. The FISA Court judges are still appointed by the Chief Justice alone. The fundamental architecture of secret judicial authorization for government surveillance remained completely intact, and in 2019, the Inspector General of the Justice Department released a damning report finding that the FBI had made at least 17 significant errors and omissions in the surveillance applications it submitted to the FISA Court, related to the surveillance of Carter Page, a former Trump campaign advisor. The FISA Court itself, in an extraordinary public statement, acknowledged it had been misled by the FBI, a secret court, approving secret surveillance, based on information it later acknowledged was inaccurate, is a problem that goes far beyond any single political controversy. It is a structural problem, built into the system itself. So what does all of this mean for an ordinary American going about their daily life? Here is the honest answer. The vast majority of Americans will never be targeted by a FISA Court surveillance order. The court is primarily focused on foreign intelligence threats and national security investigations. But here is what is worth understanding clearly. The architecture exists. A legal framework that allows the government to monitor American communications in secret with judicial approval that is almost never denied, is a framework that depends entirely on the good faith and restraint of those in power. History has shown, repeatedly, that government surveillance powers created for one purpose have a way of expanding to reach far beyond their original intent. The FBI's illegal surveillance of civil rights leaders in the 1960s was conducted under programs that began as legitimate national security operations. The NSA's bulk collection of American phone records began as a program specifically targeting foreign terrorists. The question is not whether the FISA Court is being abused right now. The question is whether a secret court that approves 99% of government requests, with no opposing counsel and no public transparency, is the kind of judicial oversight the founders of this country had in mind when they wrote the Fourth Amendment. The right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures shall not be violated. Those words were written by people who had lived under a government that searched without accountability. They knew exactly what they were trying to prevent. Whether the FISA Court lives up to that standard is a question every American deserves to be able to answer for themselves. Did you know the FISA Court existed before watching this video? Drop yes or no in the comments. I read and replied to every single one. And if this changed how you think about government surveillance and judicial oversight, share it. Because most Americans have never heard of a court that has authorized tens of thousands of secret surveillance orders, and they should. This is Government Files USA. We open the files they never wanted you to read. Subscribe, new file every single week. Next week, the app on your phone that is legally sharing your location with the government right now. Stay informed.